Good afternoon, and welcome to the American Constitution Society's annual Supreme Court review. I'm Russ Feingold, and I'm the president of ACS, as you likely know, and it is a national network of lawyers and law students, scholars, and policymakers who believe that the law should be a force for protecting our democracy and improving people's lives. Now, before we dive into today's program, I just want to take a moment to recognize two giants and friends of ACS who we lost recently. Congressman John Lewis was an amazing hero, champion for justice, and friend who lived and taught us the value of good trouble. His decades of service in Congress, leading protests, fighting for equality and against racial segregation and social injustice, helped us get us closer to a constitution for all people. I will always treasure a personal tour he gave me of the Civil Rights Museum in Memphis several years ago, where he humbly told me his firsthand accounts of his experiences. I'll remember him as a gentle and yet powerful teacher. He was a champion for the right to vote, and we must work together to continue that legacy and honor his memory. We send our deepest sympathies to all who are feeling this loss. We also sadly lost a former ACS board member recently, Steve Sussman. Steve was a terrific leader and litigator whose passion for the law we all benefited from. Specifically, Steve was very keen on trial by jury. We were very fortunate to count Steve as an active member and supporter of ACS. His contributions to the legal profession and the work of the American Constitution Society will always be cherished. He lived the values that ACS stands for, and we send our condolences to his family and friends. May both Congressman John Lewis and Steve Sussman rest in power as we honor them by continuing to work toward the visions they set out and actually lived. It probably goes without saying that we are living in the most unusual and challenging of times, and the Supreme Court term that just finally finished 2 weeks ago provided further evidence of that. For starters, not since 1966 has the court term extended past the month of June. And if that weren't unusual enough, some court watchers have been debating whether or not Chief Justice John Roberts, now apparently the court's swing vote, has become a liberal. I think we know the answer to that. Ahead of this tremendous panel, I do want to highlight one set of cases that we at ACS care about deeply: the death penalty challenges, in which the court just last week failed to intervene to stop executions now that the federal government has decided to resume them. In dissent from the court's refusal to issue a stay in either of the first two executions, Justice Breyer wrote, "A modern system of criminal justice must be reasonably accurate, fair, humane, and timely. Our recent experience with the federal government's resumption of execution adds to the mounting body of evidence that the death penalty cannot be reconciled with those values." And he goes on to urge a reconsideration of the death penalty's constitutionality. I hope we'll all heed Justice Breyer's call and that ultimately the court will too. I urge all of you to have a look at our newly created resource page on the ACS website that contains programming and scholarship on this subject, and to work with us to seek the death penalty's abolition. I, of course, want to thank all of our generous sponsors who make this and our other programming possible. So now it's my great pleasure to introduce Tom Goldstein, one of the nation's most experienced and respected Supreme Court practitioners, a partner at Goldstein and Russell and co-founder and publisher of that invaluable resource known as SCOTUS blog. Tom has served as counsel to a party in well over 100 merit cases at the Supreme Court. He has taught Supreme Court litigation at Harvard Law School and Stanford Law School, and has been repeatedly recognized as one of the nation's top appellate advocates. We are surely grateful that he has repeatedly agreed to moderate this national event for ACS. Please join me in welcoming Tom Goldstein.
Thank you so much. I know that so many people in ACS join me in being so excited that we have Senator Feingold's leadership. It is an incredible thing for the organization and an incredibly exciting time. Also, a really, really remarkable Supreme Court term. And while obviously the COVID pandemic makes for many unfortunate situations in the country, one tiny glimmer of good news from this is the ability of so many more people, other than just through C-SPAN, but so many more people to be able to join us in this program and join me in welcoming the panelists that we have. What we've tried to do is break up the really most significant cases of the term in the hope that we can derive from them broader lessons about what's going on in the Supreme Court. Now, we could talk about any of maybe 10 or 15 cases in any other year. It just so happens that this term is so jam-packed with really monumental decisions and some cases that had the potential to be monumental but ultimately weren't. But we've tried to divide this up evenly so that each of our panelists will talk over the course of the program for around 10 minutes. Generally speaking, they'll talk for about 6, 7, or 8 minutes about one principal case, and then we'll follow up and comment on another case. And then we are going to be sure to leave time at the end for your questions. With hundreds and hundreds of people online, which is a fantastic thing. It's obviously a little bit harder to navigate some of these sorts of things, but now I think we're all getting used to the experience of Zoom type meetings and the opportunities that they create and the difficulties that we can overcome. So I'm going to introduce our panelists as we go through. We're going to start with Fatima Goss-Graves, who is the president and CEO of the National Women's Law Center, which has been involved in an extraordinary number of cases at the Supreme Court, not just this term, but over the course of many, many, many years, of course, and played a leadership role in essentially every issue relating to and affecting women at the Supreme Court, which, as we all know, is a lot of them. And she is going to take the lead for us on the terms major, ultimately a single, but originally a pair of cases involving Title VII.
Well, thank you so much, Tom. And I also just wanted to begin by echoing my gratitude to ACS and Senator Feingold. And we're so excited to have you in this role. The big sex discrimination case this term was the trio of cases, but one decision in Bostock versus Clayton County. And in that case, Justice Gorsuch really presented squarely the question of whether employers in the country can fire people for their sexual orientation and gender identity. And really, in many ways, the first paragraph of the opinion really tells you almost all the things that you need to know when Justice Gorsuch said very squarely that an employer who fires an individual for being, sort of outdated language, homosexual or transgender, fires that person for traits or actions it would not have questioned on members of a different sex. So he went on then to then say sex plays a necessary and indistinguishable role in the decision, exactly what Title VII forbids. So it goes that if Gerald Bostock, a man, would not have been fired for attraction to another man if he were in fact a woman. And it is a huge victory in so many ways. It is a victory much in the fact that some of the arguments
Fatima?
raised by
Fatima?
the
Fatima? Sorry for interrupting. I think we may just have, hold on a second. Fatima, we may have just a problem with your network connection, unfortunately.
Justice Alito wrote that a long argument around the time of its drafting
All right, we may unfortunately have lost access to Fatima for a second for internet connection reasons. So let me just pause, and maybe what we'll do, Victoria, if you don't mind, is step in and ask you to talk about the dispute, the pair of disputes at the court this term over access to the president's financial records. Victoria Norris is at Georgetown, and particularly relevant here, given that one of the subpoenas was issued by the House, or a couple of them, is the director of the Center for Congressional Studies at the law school. So Victoria.
Thank you so much, Tom. And I just want to say thank you to Senator Feingold as one of 2% of all law professors who've ever worked as a lawyer in Congress. I'm delighted to see Senator Feingold as the new president of ACS. So I'm going to talk about the two Trump tax cases. That's how they're popularly known. They're actually, in both cases, seeking records from accountants and banks in the two different contexts. So I'll talk about them just generally as one, the New York case. That's a grand jury proceeding where information from the president has been subpoenaed for that grand jury by the New York district attorney. And then the other case is the Congress case, and that is Mazars. And in that case, Congress, the House, has subpoenaed the president for his not only tax returns, but other accounting records in connection with investigations involving money laundering and perhaps foreign interference in our elections. So Mazars was a 7-2 decision with Justices Thomas and Alito dissenting, and in Vance was also 7-2, although again with the same dissenters, but Justice Gorsuch and Justice Kavanaugh concurred in the judgment. So the press reported these cases as being a tremendous victory for the rule of law. I'm a bit more skeptical than that. It's certainly true that the Supreme Court rejected the Consovoy firm's arguments that the president was absolutely immune. However, in the United States versus Nixon, no one had contemplated that the president was absolutely immune. And in fact, the court had rejected that in Nixon and again in Clinton. So it wasn't precisely the same case, but one could have cited a number of cases suggesting that that principle that the president's private lawyers were arguing was quite extreme. And so to say that it was a victory for the rule of law, it was not as powerful a victory. It was really rather small in my view for the reasons I'm going to about to explain. First, I think the people failed, or people lost. I'll correct the record on that. They lost because they're not going to see these records before the election. Why? In the Vance case in New York, it's subject to grand jury secrecy. In the Mazars case, the Supreme Court created a new 4-part standard that the dissenter suggested fell from heaven. This standard has to be adjudicated on appeal. There were gestures in the opinion to potentially relitigating some constitutional arguments. And so it's going to take some time to do that on remand, despite the House's attempt to expedite the mandate in the Supreme Court. That failed. The proceedings in the Vance case were expedited, but not Congress's case. And that comes to one of the themes that I'm going to talk about, which is that Congress lost here. If you study Congress, you realize that for 100 years, since 1927, in a case involving Attorney General Harry Doherty and the Teapot Dome scandal, that the court has actually been very lenient in allowing Congress to investigate executive branch misconduct. This from a conservative 1920s court. And what has happened now in Mazars is that the court has set a new standard, as I said, the one that sort of fell from heaven. And this standard, interestingly enough, only applies to the president. So Mazars is a third-party private entity, gets these subpoenas every day. People don't think this happens as often as it does. Why? Congress investigates waste, fraud, and abuse, and you want them to do that, as Senator Feingold knows. They do this because they want to get from banks or nursing homes or all sorts of people documents that they don't want to reveal. And so there's one standard that still remains to apply to them, and it's very lenient for Congress. Congress's legislative purpose is presumed under McGrain versus Doherty, which was not overruled in the Mazars case. So if I or Tom or the senator receive a subpoena from Congress, we have to comply under the old rules. But one person, namely the president, has a separate standard now. So I call this, in a blog I did for ACS, presidential exceptionalism. So he has his own rule now. And this rule is said to come from the separation of powers. And for me, I have to tell you, I've been studying, I wrote my first article on the Federalist Papers and the separation of powers in 1995. So this is quite a term for me. There are not that many cases on the separation of powers. And so it really is fascinating that the court found in cases involving a private party that there was a separation of powers concern on behalf of the president. And law professors are going to spend a lot of time trying to figure that out. Now, as far as Congress's new standard, it's unclear, how that's going to move forward. But I think you also need to understand that the rhetoric of the opinion is very much President good, Congress bad. I'll give you some of the adjectives that are used about Congress. Its power can be imperious and dangerous. They're liable to harassment. Now, all of these arguments were raised in the Vance case, and they were rejected in the Vance case. They were rejected in McGrain versus Doherty in 1927, and they were rejected in Clinton versus Jones. So on the other hand, you have those negative adjectives with respect to Congress. On the part of the president, he has the entire executive power. He is the president alone. And this is the rhetoric of the unitary executive. And I've written quite critically about this because I think the court, since I also spent a lot of time on statutory interpretation, is actually creating constitutional text that does not exist, okay? Article 2 does not say, as Justice Scalia once said in his famous or infamous dissent in Morrison versus Olson, the special counsel case, it does not say that the president has all executive power. It doesn't say the president alone, and it doesn't say he has the entire executive power. But the court is now using those terms, all right? And they are using those terms because this is the language of the unitary executive. So while on the one hand, the president's records will and are subject to the rule of law in a criminal proceeding in New York, and as well in Congress eventually perhaps, on the other hand, the court is actually laying the groundwork for a very strong view of presidential power, which can bleed over into other areas. At the end of this, we might talk about a case involving the Cfpb, which is a different kind of argument. But the unitary executive has this habit of bleeding from one area to the another. We just saw here, John Yoo arguing that the Daca case somehow allowed President Trump more power. I don't read the Daca case that way. But unitary executives are true believers. And so I think this is a negative aspect of the opinion that dovetails with this other case involving the Cfpb, in which we are likely to see more and more arguments on behalf of strong presidential power. And obviously some people think, well, if the president's different, I might like that. I happen to think that what's really at stake here is less so much about president's power than really an attack on the administrative state, an attack against Congress' creation of rules and regulations and Congress's attempt to regulate the presidency. If you have the extraordinary honor, as I did, to work in the White House, I was, a counsel for Joe Biden, you'll know that we're highly regulated. And we took that regulation very seriously. People in the unitary executive believe that the president himself and perhaps the office of the presidency, which currently now is highly regulated in terms of ethics, in terms of paperwork, in terms of advisory committees, they believe that may be unconstitutional. So amid the obvious tax return issue, for lawyers, if you read this opinion, you'll see that this is a court that believes in a strong president, but also a very weak Congress.
So Victoria, can I just ask, who do you think ultimately wins? Understanding that the big picture question is, of course, what you talked about. And that is like, what's the rule of law going to be going forward? Who do you think ultimately wins in the fights over these subpoenas, given that they were sent back to the lower courts? Or is it still a jump ball, do you think?
Well, I think ultimately, I think that who wins actually are county attorney generals. Or district attorneys, sorry. We've seen state attorney generals. They've got a lot of power to attack administrative regulations. Now we have individual county attorneys that can bring a criminal proceeding against a president. And remember, I taught criminal law for 15 years. The criminal law is vast. That's why we have mass incarceration. And it's vast with respect to white collar crime as well. So if you make a false statement in a public document, even when you're a private citizen, that is a felony. So this allows an enormous amount of power, and strangely more power, to Vance up in New York than it does to the entire Congress, which is something I noted in my blog, which is very odd in some ways.
And so do you actually read the decision to allow the criminal prosecution as opposed to the grand jury subpoena of the president?
Well, I think
Or of third parties?
I'm sorry, say that again, Tom.
As opposed to a grand jury subpoena of third parties, you read the decision to signal that you could actually indict the president?
Well, that's a fascinating question. Obviously, if you're a strong presidentialist, you believe, as the Justice Department has often said for both Republican and Democratic presidents, that you can't indict a sitting president. I don't think this court would allow that. But they are hewing to the notion that the rule of law at a minimum has to protect individuals, as they did in Nixon. So it was the Watergate burglars, it was a third party. So in a third party case, the president must give evidence, as even was done in the Burr case. So I believe that is a victory for the rule of law. I do think that there are shenanigans that are likely to happen in the future with county attorneys, potentially because of the vastness of the criminal law, because you can obtain documents this way, even if you can't indict the president. And I wonder why the court was willing in these cases to say that's not a danger or potential harassment, when they said that Congress is so much more capable of harassment, because frankly, it's harder to get 535 people to agree than a single county attorney. So that there are structural disincentives, actually, that people disregard typically about when they talk about Congress, so they think politics is messy. But I do think there's a lot of incentives now for the party out of power to find a district attorney to make some allegations. I mean, that's the kind of world we live in. I mean, I wouldn't encourage it. I don't think there are many restraints on that, such as the structural restraint I just said on Congress. I know that Senator Feingold knows how hard it is to get things done there, and that is a really powerful difficulty. So this harassment notion, even though it's from the House, strikes me as it just a visceral reaction by lawyers that they don't like Congress. And I understand people don't like Congress, but I think what you have to, I tell my students is cross out Congress and put the word democracy in there. Cross out politics and partisanship and put the word democracy there, and see how you feel about the same structural arrangement. So I'm worried about that transfer structurally of the power to get private information. Now, most presidents, by the way, as I've said in another ACS blog, they've been vetted so much that this would have had something like this would have happened before, or we would have known about it. And some presidents might even, and I suggested this, perhaps Barack Obama might have viewed this as a way to resolve certain things, you know. If you were alleged to file in document when he was in private life saying that he was a citizen, but that wasn't a citizen, and he knew he wasn't a citizen. Obviously, this was a conspiracy theory. I disagree with that entirely. But he might have been able to use that to actually resolve the matter in a court of law. So it's not as if we know yet. I think there's a lot of jump balls here is the bottom line. We don't even know whether the Second Circuit will actually, apply the standard of the DC Circuit in a way that will allow the Congress to get the documents.
Yeah, and it'll be very interesting to see how the president's arguments about harassment play out on remand in the Vance case itself. I think they're probably not going very far. Let's move on to my friend Jonathan Adler, who is both a specialist in environmental law, and we'll come back to that in a little bit, but is really just one of the nation's most active and respected legal thinkers, and is going to take the lead for us on the court's very significant abortion ruling.
Sure. Well, thank you, Tom. It's a pleasure to be here. Too bad that we can't be in person, but I always enjoy doing these panels, and it's nice to be back with ACS again. So as Tom noted, the court heard a significant abortion challenge this year, and it produced what I think is an important and significant ruling, and one that I think in many ways encapsulates a lot of what we're seeing on the Roberts Court, especially now that the Chief Justice appears to be the median justice now that Justice Kennedy is lost. This case involved a challenge to a law in Louisiana, 620, which imposed various restrictions on abortion providers. In particular, or most notably, it required doctors performing abortions to have admitting privileges at hospitals within 30 miles. In the district court found that this would dramatically reduce the number of abortion providers in the state of Louisiana. As I think viewers know, the Supreme Court struck down a virtually identical law in Texas 4 years ago in a case called Whole Women's Health versus Hellerstedt. And on the table in this case was not simply whether or not the Louisiana law constituted an undue burden under the standard set forth in the Casey decision, but also whether the court should either overturn the Whole Women's Health decision or, in the alternative, conclude that abortion providers, doctors providing abortions, do not have third-party standing to challenge the restrictions. So an issue in this case was, if the right in question is the right that belongs to the woman to terminate her pregnancy, does this mean that you need a plaintiff who actually is a woman seeking an abortion, as opposed to abortion providers? And it's generally recognized that that shift in standing law would make it significantly more difficult to mount challenges to state abortion laws. So the court narrowly, 5-4, or in some respects 4-1-4, concluded that there is third-party standing, that the interests of abortion clinics is sufficiently close that they can raise these challenges, and concluded that the law in question does constitute an undue burden on the right of women to terminate a pregnancy, much as the similar law in Texas had. Justice Breyer wrote an opinion for himself and 3 other justices, so a 4-justice opinion, largely echoing the analysis he had provided in Whole Women's Health, which said that an undue burden is in part a question of whether or not the obstacle placed in the way of a woman seeking to obtain an abortion is disproportionate to the benefits that the state claims the law provides. And Justice Breyer said that the district court found that this would impose a significant burden, dramatically reducing the availability of abortion in the state, and that there were no offsetting benefits to women's health that the state had been able to identify that could somehow justify that burden. And so in Justice Breyer's view, we understand undue burden as is the burden imposed undue in relation to the benefits that the state is seeking to achieve. The 5th vote to strike down the statute was provided by Chief Justice Roberts. And Chief Justice Roberts, while concluding that Whole Women's Health should not be overturned and had to be followed, and that an equivalent law needed to be invalidated, rejected the analysis that Justice Breyer provided. And in some respects, what you see between Justice Breyer and Chief Justice Roberts is some jousting over the meaning of Casey. And this is jousting that we have seen over the last 25 years. As I think viewers know, the Casey opinion, the holding of Casey, that laws that impose an undue burden, that impose a substantial obstacle to a significant number of women seeking to obtain an abortion, that holding was articulated in a joint opinion joined by 3 justices. In subsequent cases, different justices, indeed different members of that 3-justice opinion, have interpreted that standard in different ways. So for example, in the pair of cases that dealt with what were referred to as partial birth abortion bans, Justice Kennedy and Justice O'Connor and Justice Souter had different conceptions of the extent to which states or the federal government could limit that one method of providing an abortion. And similarly, you see here between Justice Breyer and Chief Justice Roberts a dispute over what it means for something to constitute an undue burden. Justice Breyer wants there to be a weighing. If a state is going to impose and create an obstacle in the path of a woman who's seeking to terminate a pregnancy, the state has to identify that there are benefits that are legitimate for the state to pursue, such as protecting the health of the woman, and that those benefits have to be significant enough to outweigh that obstacle. Chief Justice Roberts doesn't agree with that sort of balancing test. He says it's purely a question of whether or not the obstacle is so great that it becomes an undue burden. He is fairly dismissive of the idea of any sort of balancing in his opinion. And he, in justifying that, points to the fact that in the Casey opinion, most of the Pennsylvania restrictions that were at issue were upheld by the court, and relies upon, in part, the decision of Gonzalez versus Carhart that had upheld the federal law prohibiting the practice often referred to as partial birth abortion, saying that the traditional rule the court should follow is that, quote, state and federal legislatures have wide discretion to pass legislation in areas where there is medical and scientific uncertainty. And so this jousting, I think, is where we're going to see the action going forward from June Medical Services. The 4 other conservative justices all dissented, all wrote separately. The combined number of pages in this case, I think, are something like 135, 140 pages. A lot of ink spilled on this issue. They all made clear that they're uncomfortable with third-party standing, and that they don't think Whole Women's Health was a correct application of Casey and would overturn it. Chief Justice Roberts, again, didn't want to overturn Whole Women's Health, but does have this more restrictive view of the right that Casey protects. And I think in this way, the Chief Justice's controlling opinion, and I'll conclude on this point, is a very Chief Justice Roberts opinion. He is a conservative minimalist, and I think we need to pay attention to both aspects of that. He's a minimalist in that he likes small decisions, he likes incremental steps, he doesn't like to overtly overturn precedent if he can avoid it, but he is still also a conservative justice. While he wants the steps to be small, he does have an idea of which direction he wants the law to move, and I think you see that in his controlling opinion in this case. Doesn't want to overturn this recent opinion, doesn't want to uphold a law that is so close to this law that the court had just invalidated 4 years ago, but yet does want to shift the nature of the inquiry, shift the doctrinal holding in a way that in the future will make it easier for states to pass laws restricting access to abortion. And I'll stop there.
So, Jonathan, what does this tell us about the future of abortion restrictions in the Supreme Court, understanding that Louisiana statute happened to end up being a twin of Texas's? What's the broader lesson that you take about where the law is going here, and what kinds of restrictions would be upheld? Or put another way, where is the Chief Spoden play and where isn't it?
Sure. So before this opinion, I think after Whole Women's Health, the focus was on, could states identify actual benefits to permissible for permissible purposes, such as protecting the health of the woman, that could offset a restriction. After this decision, the need to show those offsetting benefits appears to drop out because Chief Justice Roberts doesn't want to see that. And so the question really is, how great a burden is being imposed? And what that, I think, means is that some of the laws that you see at the state level that are somewhat symbolic and are certainly aimed to discredit abortion or make abortion less, to denormalize abortion as a medical procedure, but that may not impose a significant financial or other burden, are likely to be upheld, even if they provide no health or other benefits. So, laws about disposal of fetal remains and things like that. I think some of the cases you see in the pipeline that restrict the purposes for which abortion can be sought. So there's some various state laws that, for example, would prohibit a doctor from performing an abortion if the doctor has reason to believe that a reason for the one wanting the abortion is, say, a Down syndrome diagnosis. I think those laws are a closer call. Now, if you just ask me to predict, I think the Chief Justice has shown he'd be inclined to figure out how that law could be justified under Casey. Whether or not that requires stretching some aspects of the Casey holding, it might, but I would reemphasize the point I made before, that that Casey was this compromise opinion, and even the three justices that wrote that controlling opinion never fully agreed on how it applies. And so we're still in this contested terrain, but it's certainly terrain that favors incremental laws by states that seek to restrict access to abortion on the margins.
Tremendous, thank you. We have back Fatima Goss-Graves, who has acted as her own technical support team. This case is obviously of enormous import to the National Women's Law Center. And so maybe, Fatima, if you'll talk about June Medical, and then we'll be sure to come back to Bostock as well.
Thank you. And even though I do what seems like thousands of Zoom calls a day, somehow for this call, I lost all ability. I agree with much of what you said, Jonathan, about it. I just wanted to emphasize a couple of additional points, though. That the first is that there were these great declarations of Justice Roberts as the new moderate of the court because of the decision. And I think we have to really keep in mind that we would have had a real crisis around the rule of law if there had been a disregarding entirely of whole women's health, which was just a few years ago, and we were talking about a statute that was nearly identical to the statute squarely in whole women's health. And so it's hard to sort of celebrate that fact that we are holding on to the contours of basic rule of law, but in these times, I guess maybe that's what we did. The second thing is, I think really Justice Roberts' concurrence was an invitation to states to keep doing what it is that they have been doing, which is every state session passing more and more abortion restrictions. There's been over 450 in the last decade. And the language that totally writes out efforts to tell a story about any benefit from this law is going to create an even wider berth, because the whole women's health direction was different, that there should be some value to these laws that are purportedly about women's health, not just a consideration of the burdens. And so I think we will continue to be deeply in the range of these fights, more so because of the concurrence that we do live to fight another day.
Thank you. And as I said, we'll come back, be sure to come back to Bostock, of course. Let's turn to immigration, if I can. Omar Jadwat is the director of the ACLU Immigrants' Rights Law Project, and the court had multiple really significant immigration cases. Can you take us through them, Omar?
Sure. Thanks, Tom, and thanks, Senator Feingold. Thanks to both of you for having me on. I'm going to talk mainly about the Daca decision, DHS versus the Regents of the University of California, and also more quickly, an important judicial review case, which is DHS versus Thorasagam. So Daca, as we know, was this program that was rolled out in 2012 under the Obama administration that provided a subset of dreamers. That is, dreamers are folks who came to the United States as children, but are undocumented, provided certain dreamers who could pass an individualized application process and fit within the program in other ways, the opportunity to get 2-year grants, 2-year renewable grants of deferred action, that is essentially protection from removal, and work permits. Hundreds of thousands of people in the United States benefited from the DACA program. There's over 700,000 people received DACA, and really obtained, as a result, the opportunity to live openly in the country that they had grown up in, to no longer live in the shadows, to be constantly threatened with removal, to be unable to work lawfully. So it made a huge difference to people's lives. In 2017, in September of 2017, the Trump administration decided to end the DACA program. And the way they decided to do it, in large part, it seems to dodge any political accountability for the decision they were making, was to have Jeff Sessions, who was then the AG, write a letter to the acting Secretary of Homeland Security and tell her that he thought the program was unlawful. She then issued a memo rescinding the DACA program on the ground of its supposed illegality. And of course, immediately thereafter, the legal challenges started. So DACA recipients themselves, organizations, universities, states, all sued and were successful in obtaining injunctions, the on-the-ground effect of which was that the government had to continue to accept renewal applications and process renewal applications from people who had DACA. The government's response legally was largely to try to push the case quickly to the Supreme Court. So they filed for cert before judgment twice, in February and in November of 2018. The case did not get on for the 2018 term. And so, we have this fairly lengthy period between when these injunctions issued in late 2017 and today. And ever since this rescission in the fall of 2017, DACA recipients, these hundreds of thousands of people in the country, have really been living in a kind of limbo. People who were once undocumented, who now have an ability to live their lives openly, to pursue careers, to live with their families, many of whom are of mixed status, to seek an education, have not known really at what point the shoe might drop, and this ability to live here would be taken away from them, and they'd be subject once again to the prospect of removal to a country perhaps that they don't know at all, where they might not speak the language or have any family. So that was the backdrop against which the Supreme Court got this case. The decision was by the chief on behalf of 5 justices. Found first that the challenges were justiciable, that the APA, the Administrative Procedures Act's presumption of review applies, and that the INA, the immigration laws, don't bar jurisdiction over these challenges. The court did not reach the question of whether DACA itself was lawful, and it denied the equal protection claims that plaintiffs had brought below. But it did find that the rescission of the DACA program was arbitrary and capricious, and therefore unlawful under the APA, because the agency had failed to consider important aspects of the problem when it decided to rescind DACA. And there are basically 2 buckets of things they failed to consider. One was the actual legal implications of the supposed illegality determination that they made, and specifically to focus on the difference between forbearing from removing people and actually granting them work authorization. But even more significantly and separately, I think these are 2 independently sufficient reasons, the government failed to consider the reliance interests that this program had engendered. And so the effects on DACA recipients, on their families, on states, on businesses, of taking away, the ability to live in this country lawfully and work in this country lawfully for such a huge group of people. And so in light of all that, the government lost, the rescission memo was vacated, and the program should be back up and running as it was before all this happened in late 2017. Looking forward, I think there are a couple of big questions that are going to play out over the next weeks or months. The first is a question that I think everyone's surprised we're even asking, which is whether the government is in fact going to comply with the Supreme Court's decision in this case, because the effect of vacating this memo is that DHS should be accepting applications for new DACA grants from folks who are out there and have never had DACA before. DHS has not at all said clearly that they are in fact going to accept those applications. And there are a lot of statements out there, statements that are still up on DHS's website they're sending applications back to folks and saying that there is no ability right now to apply for initial DACA. And so, whether the administration is going to keep this up and actually, directly violate the Supreme Court's resolution of this case, including now, and now there are additional judicial orders making it clear that they have to accept these new applications, is something that I think a lot of people, that we're all going to be keeping our eyes on going forward. The other, I think, big question is what the administration is going to do next about the DACA program. There were a lot of statements initially from the administration saying that they would refile papers to get rid of DACA again. And I think those statements kind of regard Roberts' decision as setting forth a roadmap, like a set of checkboxes. If you just say these 8 things, you can get rid of DACA and the court's not going to stand in your way. I think that's actually, too cribbed a reading of what the court actually did, because the court didn't purport to set out, I think, a complete list of all the factors that mattered or any particular combination of any particular way and scope of a termination that would be lawful. And I think what the decision really says is that, like, you really have to engage with these reliance interests, and whatever reasons are given, right? Even if it's not illegality the next time around, those reasons are really going to be rigorously analyzed, and there's going to have to be a real fit between, these reasons, the shape of whatever rescission decision is made, and with a real demonstration that these reliance interests are genuinely taken into account. And I think that there's plenty of evidence to suggest that this administration, on an issue like this, is really incapable of doing anything that looks like reasoned analysis. That that what they've shown time again and again is that they're gonna shortcut the processes, do things in a sloppy way, and I think there's a big question about whether they have any capability of doing what the APA requires in these circumstances.
Omar, can I ask a question?
Yeah.
That is, there is at least some realistic possibility that they'll run out of time and there won't be a Trump administration anymore. What does all this teach us about the lawsuit that's still pending that says that DACA was illegal to begin with, right? Is that not the more prevalent, urgent challenge given how that district court has looked at the program?
Yeah, so I mean, I think that is kind of an important next step in the litigation-wise in terms of what happens next, right? So the judge in that case had denied a preliminary injunction motion from the state plaintiffs who were challenging the DACA program, saying that the balance of the equities actually favored not issuing an injunction, even if they had shown some likelihood of success on the merits. The parties are going to be back before that judge talking about what the next steps have to be. I don't know that the case is, or actually, I think the case is not sufficiently teed up for it to proceed to final judgment as things are. So I think there's a long, in my view, there ought to be a long runway before there's any decision in that case as well. So the clock is going to be running, I think, even there.
Right, but is it fair to say that the reaction that when the administration lost the DACA case, that the enthusiasm that, well, if the administration is voted out of office and we have a Biden administration, then that would naturally be inclined to keep DACA, that may not be the end of it, right? That there is still a major fight pending.
Yeah, I think because the legality question is unresolved by the Supreme Court's decision, and there's obviously the previous litigation over the DAPA program, which was a kind of follow-on program to DACA. Those challenges are likely to continue. I would be very surprised if an incoming administration thought that they could just kind of, in light of the DACA decision, just kind of keep trucking along the way things were, and not, at a minimum, have to contend with challenges from states like Texas, and and my assumption is that folks who are involved in thinking through these issues are really trying to think through other ways where you could provide protection for people that don't look exactly like the existing programs.
Do you want to talk briefly about the judicial
Sure.
review case?
Yeah. So Trossinghem, and I should say at the outset, this is one of our cases. My colleague Lee Gallant argued this one. This is a case involving Vijay Kumar Trossinghem, who's a Tamil man from Sri Lanka who fled after being kidnapped and beaten in an incident that kind of mapped exactly to the sort of well-documented pattern of abductions by government agents who were persecuting Tamils in Sri Lanka. He entered the United States quickly, just on the other side of the border, encountered immigration agents, he sought asylum, and he was put through an expedited removal process, got a summary removal order because they rejected his claim. So the question before the court was, could he bring a habeas petition to challenge legal errors in the way that the government resolved his asylum claim? And the court said no. The court first said that for an asylum seeker in expedited removal who's just crossed the border, the suspension clause doesn't guarantee him the right to file a habeas corpus petition that doesn't seek release from custody, but instead alleges this legal error with his removal order. The court also reached out to decide a major constitutional question that was not in the question presented, was impressed by the respondents, wasn't addressed really by the Ninth Circuit below, and found that the due process clause also doesn't cover someone in Mr. Trossingham's position raising this sort of a claim. I think it's a deeply problematic decision. Abandoning judicial review over this class of claims, given the life or death stakes that they involve, and the incredibly abbreviated procedures that the statute provides, and what we're seeing, these daily assaults on the legal right to seek asylum, clear, repeated governmental attempts to just violate the law in terms of how they process asylum seekers. That against that backdrop, to walk away from judicial supervision of what's happening, is deeply disappointing. And of course there's loose language. There's a lot of loose language in the case that suggests there might be even deeper damage to habeas corpus or to due process that results. And I think there's going to be more litigation, obviously, around some of that loose language, around exactly what the scope of the decision is going forward. But the hope is that this provokes some Congress, maybe not this Congress, but some Congress, to abandon the summary expedited removal process and really reestablish effective judicial review in the immigration system. Because otherwise, in these very high risk, very high stakes situations, there's going to be no way to ensure that the government's conduct conforms with the law.
All right, thanks so much. Let's turn to religion, which I think there's a really strong case to be made, is the area of the law where the court has moved the most recently in a conservative direction. Micah Schwartzman, who specializes in these questions at the University of Virginia Law School, will take us through those. And then we can also hopefully get to the intersection of some of these two different sets of cases, like about Title VII and whether there may end up being religious-related exemptions there and the like. So Micah?
Thanks, Tom, and to everyone at ACS and to Senator Feingold for having me. So my job is to talk about the religion cases from this term, and it was a big one for these cases involving religious freedom. In fact, these three were not the only cases the court considered this term. There were other cases that were on the docket, and we may see some of them come back involving wedding vendors. We have a case already scheduled for the fall, Fulton against City of Philadelphia. So this court has been seeing a lot more interest in cases in this area, and I expect that to continue. But the three that I'm going to review are Espinoza against Montana Department of Revenue, Our Lady of Guadalupe against Morrissey Baru, and Little Sisters of the Poor against Pennsylvania. I think these cases raise two broad questions. The first is, how much does the state have to support religious groups to provide them with aid and taxpayer dollars? And the second major question is, to what extent can the government exempt religious organizations from general laws, especially when those exemptions are going to impose significant harms or burdens on other people, on people who don't benefit from the religious exemptions at issue. Let me start with Espinoza against Montana Department of Revenue. This case is about whether states that provide support for private education have to include religious schools. And I think it's useful in thinking about that question to step back from the particular facts of this case and see that we've gone through roughly 3 periods involving the doctrine in this area. From the 1940s, when the Supreme Court incorporated the Establishment Clause and applied them against the states, through Lemon v. Kurtzman in the 1970s and into the 1980s, the court took something like a separationist approach. That is, it was skeptical about aid to religious organizations and imposed some fairly serious limits on how states could support religious groups, especially in the context of private education. In the 1980s through the early 2000s, the court began to shift its position. And then in the early 2000s, especially in a case called Mitchell against Helms, and then in a well-known case called Zellman involving school vouchers, the court seemed to shift its position from a no aid posture, a separationist posture, to a much more permissive one. That is, whereas before states could not fund religious organizations, now they were permitted to. If they wanted to send taxpayer dollars in the direction of religious schools, there were means by which they could do it. We're now entering, I think, a third period. So we've gone from no aid to permission, and now to a requirement that when states provide taxpayer support for private education, they're required to include religious schools as part of that support. And the case that now most represents that is the one that was decided this term, Espinoza. Espinoza is in some ways a sequel to a case from 2017, Trinity Lutheran, in which the court held that the state of Missouri could not exclude a religious school from a grant program involving a resurfacing of playgrounds, right? You want to put the rubber on the playground so that kids don't get hurt when they're playing on them. Trinity Lutheran held that it was a violation of the Free Exercise Clause to exclude religious schools from that grant program, which provided a general public benefit. The chief writing for the court said that a state couldn't exclude a group on the basis of its religious identity. But Trinity Lutheran left open whether the court would extend that holding to programs involving religious education more directly, especially to vouchers or to tax credit programs that would support the central educational mission of a religious group. And Espinoza answers that question. Here, a 5-4 court with Chief Justice Roberts delivering the opinion of the conservative majority says that the state of Montana cannot, on the basis of a state constitutional provision, exclude religious schools from a tax credit program that provides scholarships for private education. The Montana Supreme Court had relied on a provision of the Montana Constitution, which dates back to the 19th century, that prohibited aid to religious schools. And the court said that application of that provision discriminated against religious institutions on the basis of their religious status, carrying forward the holding in Trinity Lutheran. The court said that violated the Free Exercise Clause and triggered strict scrutiny, which the state couldn't satisfy. There were this time dissenting opinions from the liberal justices. I won't go into them now because I've got a fair amount of ground to cover, but they defend something like a play within the joints position where the states have more latitude for for funding private schools without having to fund religious schools. Going forward, I think it's fairly clear that when the state provides a general public benefit, it can't exclude religious entities on the basis of their status. That's an important holding. And when you think about some of the public funding programs that are going on right now, like the CARES Act and the Paycheck Protection Program, these decisions under Trinity Lutheran and under Espinoza are quite significant. The second major case that came out from this term is Our Lady of Guadalupe School. This case involved the Ministerial Exception. That exception had been constitutionalized by the court in Hosanna Tabor, decided in 2012, so 7 or so years ago. The Ministerial Exception is based on both the free exercise and establishment clauses of the First Amendment. And it says that when churches make decisions about hiring and firing quote unquote ministers, they have constitutional protection and immunity from anti-discrimination laws like the Americans with Disability Act or the Age Discrimination and Employment Act, which provide protection for employees against various sorts of discrimination. In Hosanna Tabor, the court applied the ministerial exception to a case brought by Cheryl Perrick, who brought a claim under the ADA and for retaliation, and it rejected her claims on the basis of this now constitutional ground. The question in Our Lady of Guadalupe School is whether the ministerial exception should be expanded to include lay teachers at religious schools. And in short, the answer is yes. Right? The court is asked, who counts as a minister? Do lay teachers count as ministers? And the answer from a majority of the court, this time 7-2, the answer is that the ministerial exception is broad enough in its scope to cover lay teachers. There are some lingering questions about the approach that the court adopts in determining who gets the protection of the ministerial exception, but it's clear that hundreds of thousands potentially of lay teachers in religious schools across the country are now stripped of protections that they might have otherwise had under various anti-discrimination laws. There's again much more to say about this case, but let me just briefly mention the facts of Little Sisters of the Poor against Pennsylvania. This case is the latest in a line of cases that takes us back to Hobby Lobby, which you'll recall is a case involving the contraceptive coverage requirements that were issued under the Obama administration pursuant to the Affordable Care Act. In Hobby Lobby, a for-profit business wanted an exemption from the contraceptive coverage requirements, and the Supreme Court granted that request for an accommodation under the Religious Freedom Restoration Act, that's RFRA. The working assumption in Hobby Lobby was that that exemption for a for-profit business would have, as Justice Alito put it in his decision in Hobby Lobby, zero cost for employees. That is, women who might lose their contraceptive coverage because of the exemption would have remedies from the government stepping in to make sure that insurers provided that coverage. In Little Sisters, and I'm skipping over here some cases that followed at Hobby Lobby, but in Little Sisters, the court is faced with a challenge to contraceptive coverage exemptions that were issued by the Trump administration. The administration granted broad and categorical exceptions for any company, for-profit or nonprofit, that had either a religious or a moral exemption to providing for contraception. And the question is whether those exemptions violate either the Administrative Procedure Act, the APA, or are required under the Religious Freedom Restoration Act, or otherwise infringe on principles under the First Amendment. The court affirms both the religious and moral exemptions from contraceptive coverage requirements under the Affordable Care Act. In an opinion for the court by Justice Thomas, the court holds that the agencies that granted the exemption were given authorization under the Affordable Care Act, that they had broad authority to issue these, that they did not, when they wrote the exemptions, violate the APA either substantively or procedurally. Justice Thomas's opinion is fairly narrow and controlled. It focuses on APA grounds. It says that the agencies could consider RFRA, but it doesn't go into the merits of a RFRA holding. Justice Alito, writing separately, joined by Justice Gorsuch, would have reached that question and held that RFRA also required these exemptions. There were dissenting opinions from the liberal justices. basically the contraceptive coverage exemptions are upheld by Little Sisters. I don't think this brings to the end or the conclusion this litigation. There might still be litigation under the APA about whether the exemptions are arbitrary and capricious, but it's pretty clear where the court is, I think, in this case, and I don't see a successful challenge in the future to these exemptions. Let me make three more general points. I think I maybe have a minute. Do I have time to make a couple points? So let me just do this really quickly. One is, if you're looking globally at these cases, you can say, I think, that religious conservatives are winning and liberals and progressives are losing. That's the general pattern of cases over the last dozen or so that have come to the court involving religious freedom. Second, we've moved from a separationist period where the predominant rule was no aid to religious organizations to a requirement that the state not discriminate in the provision of public benefits. That is, if the state is going to fund private organizations, it has to include religious organizations as well. And third, we have a court that is more solicitous of religious exemptions than I think any court in the history of the Supreme Court at this point. And that raises a question about how the court is going to deal with cases where the state is both funding religious organizations and those organizations are seeking exemptions. In fact, we have a case now scheduled for the fall that poses that problem. That's Fulton against a challenge by Catholic Social Services in the adoption service context, whether the state has to continue to provide a contract and funding for that organization, even though it doesn't want to follow anti-discrimination rules. The last thing I want to say is, many of these cases show a distinctive pattern. Many of them are decided 7-2. Our Lady of Guadalupe, Little Sisters, prior to this case, Masterpiece Cake Shop, American Legion involving a large cross that was supported by the state in Maryland, Trinity Lutheran is 7-2. Many of these cases look lopsided. Breyer and Kagan are joining the conservative justices, and liberals and progressives might be somewhat puzzled about this. Like, what is going on here? And I think some of the conventional answers to that question involve Bostock, which we haven't quite covered, but we will. That is that the liberals and some of the centrists on the court, more to the right, but still not as far over as, say, Justice Thomas Alito, are trying to forge some kind of bipartisan or nonpartisan breakthrough in the culture wars, that they're striking some kind of deal where we're going to grant non-discrimination. We're going to extend non-discrimination requirements to gays and lesbians, to the LGBTQ community, but we're also going to grant religious exemptions. I have to say, I'm somewhat skeptical about this conventional wisdom that's now emerging about the new compromise from the court, partly because the 7-2 pattern extends beyond cases that are directly involved in that question, but partly also because we just don't know the full extent of the nature of the accommodations that the court might be prepared to grant. Some of these exemptions impose very significant harms on lots and lots of people. And I think there's a question about how far the court is willing to go along those lines, what the outer limits are here. And I don't think we'll know the answer to that question until we have an argument in Fulton, which will be at the beginning of next term. Thanks.
Thanks, Micah. So we're going to do a bit of a rapid fire round with Fatima giving us a reaction about Little Sisters, Jonathan talking about the Maui case, and Victoria about Celia Law. And then we're still going to make sure that we have time to come back to Bostock and answer a few questions. So Fatima?
Sure. I just wanted to point out, many people are talking about and framing Little Sisters as a case that's really largely about religion. But, we were involved and have our own separate case against the Trump administration's rule because we see this as a case core to gender equality. This case is about whether women workers will be able to have access to critical health care they need from their regular insurance plan, or whether, as Justice Ginsburg emphasized in her dissent, whether they have to be left to fend for themselves and pay more to access contraception. And the birth control requirement is a part of the Affordable Care Act that was specifically created and designed to ensure that women's preventative health services were met just the same as men. That's why there was a a separate provision and a separate detailed process around it. So it is steeped in what it means to be equal, and birth control is critical to gender equality because it's central to deciding not only whether and when to start a family, but really fundamental in core participation in things like education and work and financial security more broadly. And so there's real worries that gets lost. I would just last note that, you know, in Justice Thomas's very long dissent, something like 8,000 words, the word women was only in there 7 times, and about half of those times were really references squarely to little sisters rather than the low-paid workers who are trying to access the full benefit.
Thanks so much. Jonathan, can we return to your specialty of environmental law and get a brief understanding of the Maui case?
Sure. So yeah, the Maui case was a very important environmental law case, and it provided what I think most observers think was an unexpected win for environmental groups. In fact, before the case was decided, environmental organizations had been trying to get the case settled because they were afraid that the Supreme Court would use this decision to narrow the scope of the Clean Water Act. At issue is the Clean Water Act requires that discharges from point sources into navigable waters obtain permits. And the question was whether or not, when you have something like, say, an underground injection well or some sort of underground discharge of pollutants, say from a sewage treatment plant, and then that pollution then migrates through groundwater into navigable waters like a river, or in the case of Maui, into the ocean, whether or not that requires a permit as well. And the Supreme Court, perhaps surprisingly, 6-3, held that where the discharge is the functional equivalent of a discharge directly into navigable waters. So you're discharging into groundwater, and you know and expect and anticipate that pollution is going to migrate into navigable waters, then you do need a permit. And as I said, that was something that was fairly unexpected. As a general matter, if you look at overall environmental cases in the Roberts Court, the side favored by business groups tends to win about 2/3 of the time in those cases. But what's interesting is that in some of the biggest cases, some of the cases with the broadest potential environmental impact, cases like Maui, cases like Massachusetts versus EPA from some time ago, environmental groups have actually done fairly well in that handful of really big cases. This was one of them, and I think folks were surprised that the Chief Justice, and especially Justice Kavanaugh, joined Justice Breyer's opinion, adopting a broader, more functional interpretation of the Clean Water Act's application.
Thank you. Victoria, can you give us a brief take on the Celia Law case? It was actually obviously structurally incredibly important.
Right. Celia Law involves the constitutionality of the structure of the CFPB, the Consumer Agency, created and recommended first by Senator Warren when she was in the White House. And it does have a rather unusual structure, but as we've seen in the theme that moderation or minimalism may not turn out to be actually minimal or moderate, I think this case is setting up a number of challenges to an age-old question, which is the constitutionality of independent agencies. The court upheld the CFPB, but they struck down what is known as a removal clause. Now, this is something that separation of powers nerds have been discussing since 1798. And really, it is about whether Congress can create an agency and protect the head of that agency from presidential removal by a clause that says the president must have a good reason, not act in bad faith, not act politically, etc. It's been a live question at least since 1935, when FDR tried to remove a guy named Mr. Humphrey, who was not doing his job, and Humphrey sued for his salary. And the court, a conservative court, said, oh, FDR, you can't do that. You have to abide by the removal clause. Unitary executives and a lot of people don't like these removal clauses. They don't like independent agencies. They think there's something wrong with them in the constitutional scheme. And Celia Law pretty much lays out a blueprint for future challenges to other independent agencies. This process has been going quite minimally. So we've had a couple of cases where the court has said, well, this particular structure is wrong. And I don't want to go into the details, but Congress, this structure is wrong. Oh, and this structure is wrong. And this structure, so it's going along minimally, but the kind of things that are being stated in the opinion are really sort of maximal for those of us who study the separation of powers. So for example, the court in federal, in the Free Enterprise Fund, in this case, adopted a theory of the removal decision of 1789, which most historians disagree with. But nevertheless, they have adopted that as the appropriate historical theory. And so they say removal is the norm, and then there are some exceptions. But there are a number of justices who want to get rid of Humphrey's executor, which means you can't have so-called independent agencies, which again follows my theme of Congress. You're not really as democratic as you think you are. The president is more democratic, and his removal power is much more important than your ability to structure agencies in a way that are depoliticized or made, created expert agencies, let's say, free from political influence.
Thanks so much. I'll note just as an aside that you, as you said, they do end up upholding the agency and finding that this law is severable. And there are a couple of big severability rulings this year, this term, that I think will play a big role in the upcoming fight over the Affordable Care Act and whether the objections there to it are severable, something that Jonathan and others have written and thought a lot about. But that is going to be a major case next term. Fatima, can we come back to Bostock?
Yes, and again, my apologies on that. So I'm not exactly sure where I got left out, so I'm just going to start from the top, which is that Justice Gorsuch's decision really made it unmistakably clear that the answer to the question of whether Title VII of the Civil Rights Act, which bans sex discrimination in employment, also covers discrimination for being homosexual or transgender, as he puts it, that the answer was unequivocally, yes, it does. He said sex plays a necessary and undisguisable role in that decision, exactly what Title VII forbids. So the story goes that Gerald Bostock, a man, would not be fired for his attraction to another man if he was, in fact, a woman. So the decision is important for so many reasons, but for the wide scope of protection that it now provides, given that about half the states did not have protections against discrimination in employment for sexual orientation or gender identity. But it also is important for what it rejects. It rejected the idea put forth by Justice Alito and Thomas that they argued that Title VII wasn't meant to cover sexual orientation or gender identity discrimination, and there was a lengthy appendix of the hundreds of other statutes that could be potentially affected by this one decision. And in truth, that is my hope, that it was both rejected, that the idea that that purpose was there, and rejected. That rejection around the many, many other statutes is a good thing because it gives us a target list to think about what it means around the protections of sex discrimination in the law, which are broad, which include sex discrimination in education and healthcare and housing. In the state laws, it includes sex discrimination protections in public accommodations. So there are a wide range of areas where this could apply. Justice Kavanaugh also argued around this literal meaning and ordinary meaning of the text view, that the ordinary meaning of sex was this narrower idea, and that was really rejected too, which I think is important. What it means around sex discrimination protections has evolved over time, as Justice Gorsuch has noted, that it includes a wide range of protections. It also rejected implicitly, and we've already seen some cases pick this point up, is the idea that it can be one or the other, that that it could not be sex discrimination protections covering also sexual orientation and gender identity protections because you sort of had to choose. But really, what you saw was the accepting of sort of Kimberly Crenshaw's long-held theory of intersectionality in many ways, that that you could be discriminated based on your sex and because you're a mother, and you could be discriminated based on sex and because of sexual orientation. And so I think we will see that show up. We already have seen this show up in cases that have talked about, since the decision, that have talked about age and sex discrimination together. And I guess the last thing that I will say is, you know, the Justice Gorsuch's textual approach, you know, many people have wondered what this will mean in other cases when he was clearly disregarding things like either purpose or whether or not there's sort of a broad scope implied. And in particular, as we think about some of the cases that are working their way through the pipeline around things like affirmative action. And so I think that is, in addition to the conversation that we've had around the connection between this and religion, that is squarely being left for another day and another fight around whether RFRA is the super statute that can be used as a defense always. And there are state versions of RFRAs also at play. So I think we're going to see a lot of this development through the years. But this is for sure a win.
Thanks so much. So let's turn to questions now. We have just a touch under 10 minutes, and I'm going to kind of go to particular panelists. Omar, if I could start with you on this question of the administration's failure to kind of follow the procedural rules. I mean, can you draw a line between the Daca decision and, for example, the census decision and, you know, some of what happened with travel ban and those sorts of things? I mean, do you view these as all like self-inflicted wounds, or is this the Supreme Court coming up with some reason to knock the administration back? How do you view this body of cases?
Yeah, I mean, I think they are self-inflicted. Well, you know, what the administration's done by taking such a, you know, kind of amateurish approach to policy change, making policy, is expose itself to these sorts of actions where the court doesn't need to get into bigger questions, doesn't need to, you know, necessarily, you know, make any big pronouncements about the law, but can strike down what the administration has done based on its failure to follow, you know, the basic rules or its perversion of the administrative processes. You know, I do think that you know, it's not sufficient for the government to be sloppy, for it to lose. I think you need the combination of you know, them providing the opportunity and these courts wanting to take it. And if you look at, you know, the cases in which the court has stepped up, I think in part what you see is that it's places where, you know, the choice that the court is making is, you know, at the fulcrum of so much public pressure and examination that that the court really has to kind of step carefully, and that you know, in other cases where the government's been equally sloppy, you know, you're not necessarily going to get the same result.
Thanks, Jonathan. You know, can we look ahead just a minute to the ACA and next term, and could you give us a kind of brief précis about what's coming on the severability question and the future of the ACA?
Sure. Well, I mean, ACA litigation is ongoing. We saw cases this term, not just with the contraception mandate, but also one about congressional funding. Next term, there is another, I guess what you characterize, frontal challenge to the Affordable Care Act. And the theory is that when Congress zeroed out the tax penalty for failing to obtain health insurance, that undid the saving construction that Chief Justice Roberts to preserve the individual mandate in NFIB versus Sebelius. And then Texas goes on to argue that this is inseverable from the rest of the statute, and so therefore the whole statute should be unwound, at least insofar as it affects the petitioners. And the Trump administration has signed on generally to that analysis. There's some technical differences that I don't think we have time to get into between Texas's theory and the Trump administration's. I think this term, as you noted, there were a bunch of cases that dealt with severability, Celia Law, the case involving robocalls. And I think what those cases show is that the plaintiffs in the ACA case really have a hard argument to make. And I should disclose that I'm on an amicus brief with Abby Gluck, Nick Bagley, and Ilya Soman, arguing that that the severability arguments just don't work. That if there is a problem with a penaltyless individual mandate, there's no reason to believe that that affects anything else in the statute, whatever one thinks of the merits of the underlying statute, because on our brief, we have a range of views on whether the ACA represents good policy. But the court has shown this term that there is a solid, probably at least 6-justice majority that takes a very minimalist view of severability, that thinks when you strike down a portion of a federal statute, you should be really reluctant to invalidate parts of the law that weren't quite at issue or that weren't squarely presented. So in the CFPB case, as Victoria was mentioning, the court carves out the limitation on removal, but lets the CFPB otherwise continue operating. And I think those are very strong indications that this court is very skeptical of arguments that would allow plaintiffs of any sort to identify one infirmity in a large statutory scheme and to use that to try and kind of pull that thread and to unravel the whole thing. I think that's what Texas and in some respects the Trump administration are asking the court to do. And I'm very skeptical that they'll find many justices that are welcome to or open to that argument. But of course, we'll see when it's argued.
Thank you. Victoria, there's been a lot in the news about how John Yoo wrote an article about the Daca decision that's sitting on the president's desk, and he's notorious for reading these things thoroughly. And I wondered about if you could explain kind of that controversy and from a, you talk about unitary executivists and someone who's a strong sense of presidential power. John certainly qualifies. What's going on?
I have a colleague, Howard Schlansky, who used to teach at Berkeley, and he says when you mention John Yoo's name to me, my head explodes. So that's a disclaimer. You can predict, and unfortunately, I actually did this when I was working in the White House, that if you rely on enforceability as the basis for your constitutional power, that you can run into problems. Now, the White House lawyers thought they won the Daca decision on standing. But the real problem is that, as I said, if a president can just say, well, I have all executive power and enforceability is executive and an executive function, then you have really broad range to take any statute and say, I'm using my enforcement power to do not X, even though Congress said X. Now, the lawyers thought they'd never get there. It was fairly predictable, it seems to me. And so what John has done is just taken that to the nth degree. In the case, I don't think this case stands for this proposition, as Omar summarized it beautifully. It basically says that the court did not consider reliance interests under the APA. But along the way, it makes some comments about how using the enforcement power, that we're not going to enforce removal on particular individuals, that enforcement authority is appropriate. And then you marry that to a strong view of the presidency, and you can get some really interesting things if a president wants to do that. So when you think of executive power, you always have to think of a president you don't like, right? So put it in their hands. And that's what exactly I was trying to do when I was arguing that there could be a boomerang. that it really has to be focused on the individual enforcement if you want to use an executive order. And that's exactly what's happened here with John Yu's claims about the meaning of the Daca decision. Before I saw that, since I had known about the difficulties with enforcement, it didn't surprise me, but that's not how I read the Daca decision. And most people, I don't think, I mean, I'd ask you, I'd ask Omar, whether you read the Daca decision that way. You have to marry it with some other assumptions that are pretty strong about the president's power.
All right, well, on that note, we will all try hard to imagine a president we don't like. It's not easy. But I want to thank everybody for participating and the hundreds of people who are, who stayed along with us. Senator Feingold for his leadership and for organizing this and introducing us. And we look forward to doing this again next term, but this time in Washington, next time in Washington. Thanks so much.